I'm on and people have called that they can't hear you, so just so you know.
Yeah, we're starting. Okay. Everyone, I'm pretty sure knows Vern. Everyone on this live event, this is the first time we've tried a live event, might be the last time. I hope it works well, but everyone that's attending will automatically have their mics muted, and I don't believe that you can change that. So if you go up to the top, there is a conversation, and you can type any questions in there and I'll be watching for them. And if we can do it, we'll take questions sort of as we go. So I will interrupt Vern if there are any, and he can answer those and then continue. So Vern Jarboe is the Sunflower Association's legal counsel, has been ever since I've been here, and I think long before that. So we're very pleased that he's so willing to provide us with this training from time to time. So I'm going to let Vern take over. And like I said, type your questions in the chat.
All right. Thank you, Linda. Actually, this firm has been the Sunflower Association counsel for a very long time, and I wouldn't know how long, but if I said 50 years, I don't think it would be an exaggeration. I think it might be longer than that. Lou Eisenbarth was association counsel for many years. Lou retired about 10 years ago, and he passed away just in the last year during this COVID time when I didn't even get to go to his service for him, but he did not die of COVID. He had other illnesses that caused his death. But anyway, Lou's no longer with us. So I've had this job for quite a little while now. It is my understanding that you can hear us even if I can't see you. So I'm going to be going through the current version of the real estate sale contract, the uniform contract that's used by the Sunflower Association. I believe Linda allotted an hour and a half for this. I'm not sure how long it will take. Normally in a live context, we deal with a lot of questions. And so your questions are welcome. Now, I found the conversation icon up at the top of the screen. It kind of looks like a little balloon coming out of a cartoon. Y'all remember printed cartoons, and you always had a little balloon with the person's speech. So that's what it looks like. So I'm dealing with the current uniform contract for Sunflower Association, and I'm just going to start at the top. First two items on the contract are the buyer and the seller. In order to have a contract legally, you have to have a buyer and a seller. One of the questions I sometimes get is, well, what if my buyer doesn't want the seller to know who they are? We call that a straw man, or sometimes a straw buyer, but that's when a buyer gets someone else to be the buyer, and there's a contract between the person who appears on the contract as the buyer and the real buyer. But that's really the only way around that. I mean, you cannot create a contract with a blank line on the buyer's side of the transaction. You have to have somebody. Now, somebody may be an entity. Sometimes in commercial, we see transactions where, as the buyer, maybe I say Vern Jarboe or assigns, because I fully intend to assign the contract once it's entered into, and as we work toward closing, I'm going to assign it over to a new limited liability company that I can create and invite investors to participate in. So in commercial, we see that sometimes, but other than that, we need to have a name of a person or an entity on both lines, buyer and seller. Now, the seller obviously ought to be the person who is in fact the current owner. In the third line of our form contract, it says, do you want to take title in joint tenancy with right of survivorship? It's very important that you be careful in terms of how you counsel people about the meaning of that. Joint tenancy is how most of us would own a home with our spouse or our significant other, because what it means is that when the first person dies, the second person owns it. Now that doesn't take the dead person's name off of the contract. I've been helping my mother recently with some issues because she's very concerned about the fact that my dad's name still appears on things. He's been deceased for several years now, and we're actually going to make an effort to help her with that by filing a copy of his death certificate, because like on her house, for example, he's deceased. So if we file a death certificate, then she will be the sole owner. Honestly, I don't think the county will change the tax statement or anything else, but we're going to at least make that effort. So that's what joint tenancy does. Now, but however, it's not a perfect tool. And oftentimes we see people who are trying to do their estate planning by way of using joint tenancy, and it works just fine. I always tell people it works fine as long as people die in the correct order. The problem is sometimes people don't. So if you have, if you're trying to help a couple buy a house and they say, well, by the way, we want our children listed on here in joint tenancy, you'd be very smart to tell them, well, you ought to get some legal advice about that to make sure that's what you really want to do. Having a child's name in joint tenancy with parents on a home may be perfectly all right and absolutely the best plan in the world. But sometimes we see unusual things happen. I remember a very kind of politically famous case here in Kansas where our former Attorney General's name was on his mother's deed as a survivorship benefit or designee, and lo and behold, he ended up with some really big litigation against him, and the question became whether or not the people in the litigation could tie up his mother's house because his name was on it. That was, I think, successfully beat off, but that just shows you how unintended consequences arise from joint tenancy. So you need to be careful about that, and don't make sure you're not providing legal advice. The next thing I want to talk about is property, and the property description starts off with a blank that says in what county the property is located, and then it says legal description, correct legal description to appear on deed as per title evidence, and then it gives the address of the property. Now that can be okay and works 98% of the time, but you need to be aware of unintended consequences here as well. For example, we had a case here in Shawnee County, 10, 15 years ago, where the realtor had written in to the property legal description per last deed of record. Well, when the title company pulled the last deed of record, it was titled from a developer to a builder, and there were two lots, lots 1 and lot 2, we'll say. So the title company didn't ask anybody; they just put lot 1 and lot 2 on the into the transaction, into the title work. And of course, the builder did own lot 1 and lot 2 because that was the last deed of record. He had built a home on one of the two lots, but had not yet started construction on the other. He did have a mortgage on both lots, and when the mortgage release came from the title company, the bank actually released both lots. The title company handling the closing then prepared a deed that said lot 1 and lot 2, and the builder signed that deed, and it was notarized and filed. So in effect, he had sold both lots. Now in reality, he didn't intend to do that. He intended to sell only the newly built home. A year or so later, he went back over to the vacant lot he thought he owned, and he was going to clean it up to prepare for the start of construction. Neighboring owner says, "What are you doing?" He says, "Getting ready to start construction." They say, "Well, no, that's our lot." And so the problem was that because the description in this line of the contract said per last deed of record, that's what the title company used, and everybody signed off on it without realizing that we were selling too much property. So it's always important, certainly at closing, at the time you get your title insurance commitment, take a look at it and see, what does it say we're selling? Are we selling the right stuff? And you know, I had a personal transaction in the last year where I was selling a group of lots, but I was also retaining ownership of several lots, and one of the lot numbers was wrong. The title company, I mean, I owned them all, title, so that was fine. But the title company had picked up an erroneous lot, and that had to be corrected. So thankfully, I actually read the title commitment and said, no, wait a minute, go back to the contract. You've got the wrong lot numbers. And, you know, the other way that this gets screwed up is if you use only the street address. I had a transaction a couple of years ago up in Jefferson County where a lot had been purchased and a home built on it. Then a second lot was purchased in a separate transaction, and a nice big garage was built on that lot. Mortgage was taken out. The mortgage was only on the lot that had the garage. Eventually, the people were foreclosed upon for non-payment of the mortgage. The foreclosure was against the lot with the garage on it. A buyer then bought, you know, you probably could have been using this form. He bought a particular street address and thought he was buying a house and a garage, but the title work came out only one lot, which was the one that had the garage. He didn't notice that. He moved in, he did all kinds of repairs to the house and lived there for a number of years. And then when he goes to sell it, the realtor working for him did the right thing, did a little bit of investigation at the county, and sure enough, said, well, now wait a minute, there's two lots here, but you only show up in the title of the one lot, not the lot that has the house. And so that's where I came into the picture and had to do a little work to clean that up. So you need to be really careful with what are we selling. You know, most of the time, if you're selling a house in town, you're going to sell lot 6, block B, such and such subdivision. You're going to be perfectly okay. But I think it is important to take a look at the county website and the you know, the aerial photograph, or look at the seller's previous title commitment. And if it shows multiple lots, say to the seller, now what are we selling here? Are we selling all of these lots, or are we just selling one? Also on the screen right now, if you have a screen, if you're on just by phone, you don't, but it talks, the next big paragraph talks about that we're selling all the stuff that's attached, and then it follows with the following exceptions. There's a couple of blank lines. This is right above paragraph 2, where paragraph 2 begins. So this is a list of all the stuff that we say is attached and that we're selling as a part of the transaction. It's very important here to give some thought to what is it that the seller wishes to retain. Is there anything that's in the category of, well, maybe it is and maybe it isn't attached to the real estate? You know, I had a case over in Kansas City, probably the most interesting case I've ever had on this subject. It involved a piece of yard art. Now, this wasn't a pink flamingo. This was a $75,000 piece of sculpture out in a garden. The seller intended to take the sculpture with them, but the buyer thought they had purchased the home with the sculpture. Now, why did the buyer assume that? Well, the foot of the sculpture was apparently in a pad of concrete, like a 4x4, as I understood it. I never saw this, but as it was described to me, it was like 4 foot by 4 foot square piece of concrete. I don't know, 4, 5, 6 inches thick, I guess. And so that the foot of the sculpture was embedded in this piece of concrete. So the buyer says, well, wait a minute, it's attached. And the seller says, no, it was delivered that way. That's the base of the sculpture. And when they brought it in, you know, they lifted it off of the truck with that 4x4 piece of concrete and sat it on the ground that way. And that's how we're taking it away. It's not part of the real estate. It's sitting there by its own weight, just like the pool table. So interesting argument. Now, when you get to court on a question like that about whether or not something is included or not, and we assume that there's nothing on these two lines. So these two lines are blank. So there's no guidance in the written contract. But if you end up in court, a judge is going to say, well, first of all, look at the contract and what does it say? So in this instance, the contract was silent on the subject of the yard art. Second thing the court's going to say is, well, if there's nothing in the contract, then how is it attached? Well, in the case of the yard art, it's just sitting there by gravity. Now, one could argue, yeah, but it's got this great big base that's, you know, on or in the dirt. And one could also argue, well, it's just sitting there by gravity. So maybe that leaves us a little unclear. The final test that courts use in looking at whether or not something's included or not is, and I'm going to put quotes around this, so envision air quotes, intent of the parties, close air quote. So we're looking for the intent of the parties. So a judge reviewing the is it in or is it not in question is going to say, well, we want to know what the intent of the parties is. I've always thought that a little bit on the odd side because, you know, if we knew what they intended, we wouldn't be asking this question. We're asking it because we don't know what the parties intended. It's unclear in some way or another. So from my perspective, I think that guidance from the court about the intent of the parties is not very helpful, I guess I'll say. Okay. Next item I would point out to you is in paragraph 2B, which deals with payment in cash. This is, I just had a hotline call question about this yesterday. It was not on our board form, it was on another board form elsewhere in the state, and they did not have it quite as clear as we have in here in 2B little I guess, where it talks about that payment in cash. And apparently what someone had done is they had put in, they had marked 2B4, which is new mortgage, and they had written cash on the line, the first blank of the line. Now their paragraph wasn't exactly like ours, but it was similar. Now, the reason that became important is that the buyer, in fact, had the buyer had gotten an appraisal, and the appraised value was less than the sale price, and that's had in this current market. And so the buyer said, "Well, I don't have to close because the appraisal came in low." And the seller said, "Well, you don't have an appraisal contingency." And they said, "Well, yeah, I do, because there's a contingency in the financing contingency that talks about not buying if it doesn't appraise, and my financing was cash. So I'm just going to say that I didn't get a loan, and therefore I don't have to close." Interesting argument. I don't know how that will shake out, but it, like I said, it's not on our form, and frankly, our form probably would not allow that same argument, which, of course, I work more intensely on our form than I do on any of the others around the state, since it's, I guess, close to home. But, you know, I think our form answers a lot of questions that others don't. Linda, would you scroll down to paragraph 3, which is on the next page, actually? Closing and possession. Closing and possession is one of the required elements. Well, actually, closing is a required element. Possession really isn't dealt with in the law, other than one would presume possession goes with closing. So when we say that they're the same, that's fine. Now, having them be exactly the same is really obviously not possible in a technical sense. Closing usually means we go to the title company, seller signs a deed, buyer pays money and gets that deed. Now, you know, in the old days, everybody would have met at the title company at the same time, and the seller would have signed the deed in front of the buyer. The title company would notarize it, show it to the buyer, and the buyer would then give it back to the title company, and they would go record it. Today, most of these closings do not happen face to face, and that's okay. But we still have a time when the buyer shows up to sign their side of the transactions, or maybe they've even done that remotely. Certainly that happens. But technically, closing happens when the deed is delivered to the buyer. So in this case of a remote closing, and the buyer pays remotely and signs the note and the mortgage remotely, and then the title company tells the buyer, "Okay, we have the deed and we will record it on your behalf," that's when closing happens. Now, closing isn't the filing of the deed. Some people think that it requires the filing of the deed, and that's not technically true. Closing happens with delivery of the deed. Now, the importance of that is if you have a closing late on a Friday, for example, and the deed isn't going to get filed until the following Monday, you've still had a closing. So The fact that it isn't filed doesn't change anything. I did have a situation where that became really important some years ago because closing happened late in the day on a Friday. In fact, as I recall, it happened after 5 o'clock on Friday. Well, the seller had canceled their insurance at midnight that night. The buyer had failed to buy insurance. There was no loan. It was a cash transaction. So on Monday, the buyer goes to place insurance, but the house is burned down in the middle. Well, you know, if you have an uninsured loss and the deal has closed, then the buyer now owns a vacant lot. So it's the buyer's problem because the risk of loss would have passed to the buyer at the time of the closing itself. So that's something to pay really close attention to, particularly when you don't have a loan. Cash transactions cause us sometimes to think about things that we wouldn't worry about in a transaction where there's a loan. You know, when there's a loan, then the lender is obviously, they're not going to close it without having an insurance binder in hand. But in a cash transaction, there isn't anybody to say, hey, wait a minute, where's the insurance? You know, it's not the responsibility of the listing realtor or the selling realtor. It's not the responsibility of the seller. It's totally the responsibility of the buyer. It's not the responsibility of the title insurance company. It is the responsibility of the buyer to take care of their own interest and make sure the property is insured. Now, as a realtor, I don't think we have a duty to do anything other than have told them, you know, you need to have insurance in force. Whether or not they do or don't, kind of not your problem. But you know, it's going to feel like your problem if you're the one involved in a transaction where the house burned down over the weekend and the buyer has paid good money for a house and now owns a vacant lot. You know, those kind of things don't happen often, but they do happen. And so part of what we do with these contracts is we try to take into consideration all of the things that might happen and try to make sure that the things which might happen, even though they may be rare, that we've got them covered. So that's an important issue. Now, in the current market, there's another thing going on with closing that I have had 2 examples of in the last couple of months. In both cases, the seller has no place to go. So the seller signed a contract to sell their house, and they have nowhere to move to. They thought they were going to have some place to move to. In one case, they thought they had a place to move to. They had identified it and they were negotiating it, but they didn't even have it in contract when they signed a contract to sell their home. As we move toward closing in that deal, the transaction where the seller was buying fell apart and just didn't go anywhere. And the seller didn't really react to that, didn't do anything to continue looking or anything like that. And so here comes closing day, and the seller says, well, I'll close, but you can't have possession because I don't have anywhere to go. And of course, the buyers are like, what? You know? Now in that case, actually, the buyers were very pleasant, nice people who agreed to, continue the closing for a number of months. So they went down the road for months, letting the seller have additional opportunity to find a place to go. Eventually, the buyer draws a line in the sand and says, no more, you got to go. And the seller says, well, too bad, so sad. I'm not going because I don't have any place to go. A lawyer gets hired for the buyer, writes a nastygram to the seller. Seller hires me. And, I met with the seller to discuss, well, okay, why aren't you closing? And the answer was, we have nowhere to go. And I said, okay, show me in the contract where it says I have nowhere to go as an excuse for not performing. In a more recent example, I had a buyer or a seller who had a house under contract when they signed the sale of their own home. But that deal fell apart because they were concerned about issues with the new home. And so they canceled that deal. And now they want to be able to walk away from the transaction they're in. And of course, in this market, as you all know better than I, inventory is pretty precious. And so, a buyer isn't just going to find a place because they say they want to. Now, these buyers will be highly motivated because they've sold their house. But in this case, the seller called me up and said, "Hey, I don't want to close. Do I have to?" And I said, "Well, if you think about it in the context of have to, I don't suppose anybody's going to come with a gun and make you close. On the other hand, if you don't close when you're supposed to, you're likely to get sued. And if you get sued, you're going to lose. And so you're going to spend money with a lawyer and you're going to lose, and you may get sued for damages." In that case, I was a little bit concerned because I felt like the price of the home was actually by contract kind of low. And so, and maybe to the tune of $30,000 low. And so I'm thinking, well, now wait a minute. If the seller doesn't close, then the buyer might sue the seller for loss of profits, because if the buyer was buying this property to flip, and I don't know if they were or not, but if they were, then they may have lost a profit opportunity by the seller refusing to close. So you need to make sure when you do paragraph 3 that the buyer and seller both realize that these deadlines here are important, and they need to be followed. And we have a little clause later on in the contract called time is of the essence, which basically says if there's a date or a deadline, then that's important. So pay attention, make sure people understand paragraph 3 as best you can. Taxes and other items to be prorated in paragraph 4. We've had some discussion at an association level in recent weeks, actually, about this paragraph and what's going to happen to appraised values on property going forward. Now, the value for properties for 2021 property taxes were set back on January 1 of 2021. And so we were seeing some of this roll up in prices that has in this current market was happening back in 2020, but it certainly has accelerated in 2021. So I think what that means is if I'm selling you my house and I tell you the property taxes are X, and that's what they were back in 2019, okay, or 2020, I guess, when I paid them. So I've paid the first and the second half based on the value at January 1, 2020. But the value on January 1, 2021 is higher. And so the 2021 taxes will be more. And that means if, let's just say, for example, that maybe my taxes were $6,000 a year in 2020, but the new valuation on my house is up by a third. And so my property taxes go up from $6,000 to $8,000. So when we prorate the taxes based upon the last year we have, that would be the taxes based on 2021, and that will be inadequate from the buyer's side.
Hey, Vern, you want to interrupt for a second?
Yes, I see your chat.
I don't think the chat for Q&A is working like we wanted it to. So if anyone has a question, can they just text it to 785-249-5779, and then I will relay it to you.
Okay.
So
you want to say that number? Sure. Say that number one more time for him, Linda.
785-249-5779.
Okay.
Vern?
Yeah, I'm on a conference call. Sorry.
Okay, thank you.
Forgot to hit D&D on my own darn phone.
Sorry, I have a couple already. That
Sure.
worked.
Let's go ahead and deal with that then.
The first one is you mentioned that someone closed and didn't get possession for months. Was that a cash transaction?
No, it involved a loan, and the good news was the lender held steady. Interest rates have been steady, as everybody knows, for a number of months now, so we haven't had any trouble with that. So there was really no problem that was created by that. And amazingly, the lender stayed in the saddle. You know, the good news was nothing changed in terms of the buyer's loan qualifications or anything like that. So it actually worked out.
Well, and there's one more, just a comment. Standard Kansas mortgage states buyer will occupy home within 60 days. I guess that's a comment, or I'm not sure if that's a question.
Well, it's probably in the form of a question. I mean, in that, if you went ahead and closed and left the seller in possession, would you be in violation of a mortgage clause that says the buyer will, occupy the home? And the answer is yes, you would. Not all mortgages have that requirement, so that would be one comment, I guess. The questioner is assuming, I'll say normal, but it also is not, 100% of the time. While I would agree that a lot of mortgages say the buyer will occupy the home, that doesn't mean that that will be true in 100% of all instances. Okay. But if it is an element of the loan, then that would create a problem with a closing without possession being transferred, because then the borrower, the buyer, would be in default in the terms of their mortgage.
One more, and then we can move on. For children, do you need a transfer deed upon death?
Well, the way the question's worded, I'm going to say that's a little awkward to say, do you need? The idea is, if you're going to, if an owner wants to transfer a property to their children on death, then yes, you would need a transfer on death deed. That would be absolutely true. But that's an estate planning question, which is really more appropriately answered by an attorney than by a realtor. A transfer on death deed is a very simple device. It is a deed that operates just like it sounds. If I signed a deed today on my home and I said transfer on death to, and I named one of my children, and assuming my wife agreed with the deed because she'd need to sign it, then upon our deaths, then it would go automatically to the child that is named. And if that's what you want, that's fine. Now, I will tell you that there are a variety of problems that arise from even transfer on death deeds, just like joint tenancy deeds. Let's say you have 3 children and you put all 3 of them down as transfer on death, and then let's say child number 1 dies before you die. Now the other 2 children become the owners of the property, and the child number 1, who predeceased the parent, has some children, which would be grandchildren of the parent, who are now in effect cut out of the estate because the property goes to the other 2 children of the deceased parent. So transfer on death and joint tenancy both have a problem in that they're not the best estate planning tool if things don't happen in a normal context. They work okay, as I say, if everybody dies in order. Normally parents die first and then children, and so that's a good thing. But and certainly as a parent, we hope that our children don't die before us, but it does happen. And so the problem becomes, if you've used either joint tenancy or transfer on death as your estate planning vehicle, as opposed to a will or a trust, then you may have an unintended consequence if somebody dies first. Now, let's say that you have 3 kids, one of them dies before you've done a transfer on death deed to your children, and you realize, oh my, I need to do something about that. And there are ways to fix that, as long as you remember to do it. So the problem with either joint tenancy deeds that include children or transfer on death deeds that include children is it's an imprecise way of handling it in the event somebody dies out of order. Can be fixed. It's not the end of the world, but you have to pay enough attention to your situation to know to do that. Okay? All right. Are we done with questions, Linda?
Yes.
Okay, cool. All righty. So I was talking about taxes, and I just want to make sure that I'm understood in this current market with the inflation of prices, we assume, those of us who've been thinking about this, that the county appraised values are going to go up significantly as a result of what's happened with price escalation. Now, you know, if in the second half of this year prices drop in response to changes in the market, then maybe they won't. But my expectation is that the prices, the value of a home on January 1 of 22 is going to be significantly higher than it was on January 1 of 21. And January 1 of 21 is probably higher than what we had on January 1 of 20. So you have to realize that under Kansas law, the value is set on January 1 of the current year. So January 1 of 21, we set the property tax value for all of 21. And that means come fall in November, when you get your tax bill, the valuation at that time is going to be based upon the value on January 1 of 2021. Now, I don't know about you, but most people I've talked to, and I know in my own personal example, that the value of my home went up a little, but it certainly did not go up by 20%, which, you know, cost of construction and other things have gone up by more than 20%. But from a timing standpoint, the value gets set on January 1 of 21, and that if that value is significantly higher than the 2020 value, prorating taxes based upon 2020 will not be fair to the buyer, because the buyer will be getting a lesser share of the taxes from the seller than they should. Okay, paragraph 5 flops from one page to the next. So if you scroll down just a little, you can get the whole thing, I believe. Yeah, there you go. Marketable title. Marketable title, by the way, does not mean perfect title. Perfect title would mean there's absolutely no liens, encumbrances, or anything else on the title to a property. And in a technical sort of a way that I'm thinking about, no title is free of any encumbrance. For example, every lot that I'm aware of, certainly there probably are some exceptions, but all platted lots have easements on them. So an easement is the right in favor of someone else to use part of my property, correct? Now, oftentimes, usually, those are easements that we want to exist. I want the water company and the sewer company and the electric company and the cable company and the telephone company, I want their services. Therefore, I also want them to have an easement so they can bring their services to me. So when I'm talking about this marketable title question, that's really a comment that no title is going to be free of all these exceptions, and you just need to recognize that. So and I believe paragraph 5 does. Now, on the other hand, if you look at paragraph 5A, so if you continue from the full paragraph, it says, if the seller shall be unable to deliver marketable title as herein provided, the contract shall be of no further force in effect. And then the paragraph right above A, seller shall convey title by general warranty deed or a deed acceptable to title company, issuing the title insurance to be delivered to the buyer at closing upon receipt of the total purchase price, free of all liens and encumbrances except. Okay, so right here in our contract, we're saying that the title is going to have some exceptions to it. And the first exception is zoning, conditions, restrictions, deed restrictions, reservation, rights of way, and covenants of record. So in other words, the buyer in the contract is agreeing to accept the property subject to all of these things. So let's think about restrictions, for example. Well, what if there is a restriction, a neighborhood restriction, homeowner's declaration, and it says you may not park recreational vehicles outdoors in the subdivision on a permanent basis. They can only be parked there for 2 days at either end of a trip, so that you can, load your stuff or take your stuff out of your RV as you're, packing and unpacking around the time of the vacation. But you can't park your RV, on the south side of the garage. I noticed the other day when I was just driving down the street, I saw somebody's in the big RV. It's one of the monsters, and it was parked in somebody's backyard. And what was interesting is they had parked it. I say it's parked in their backyard. This is what it appears to me. It's parked in their backyard outside their fence. So they have a nice wooden privacy fence to protect their backyard that they want to use, but they park the RV outside the fence, so they don't have to look at their own RV, but the neighbors do because it's exposed to view from the neighbors. What an interesting way of thinking. But if you have only so much room, you have only so much room. So the point is, if I've signed this contract agreeing to take a property subject to easements and restrictions of record, and one of those restrictions says I can't park my RV there, but when I look at the property, one of the attractions to me, or for me, I guess, with respect to the property is a great big concrete pad on the south side of the garage. And I'm thinking in my head, I'm saying, oh, good, there's a place I can park my RV. I won't have to pay storage anymore. Well, guess what? I bought the property subject to a recorded easement or a restriction rather, that says I can't do that. So if you're working with a buyer on a transaction, you need to look carefully at the seller's disclosure form. And does it say there are declarations of restrictions? And if there are, you need to advise the buyer, hey, this is something that you should look at before you sign the contract, because it's too late after you've signed the contract. If you sign this contract saying that you accept recorded restrictions, then you don't have a right to complain about them if you don't like them at the time of closing. Okay? All right. Let's scroll down now to, let's go down to paragraph 11A, disclosures. Now, paragraph 11A is really mostly a restatement of what the law is. So what is the law? Well, Kansas law says that a seller needs to disclose to a buyer all defects in the property which would not be readily observable. The law does indicate that a buyer is responsible for a reasonable degree of inspection, and anything that's apparent, they doesn't have to technically be written down. On the other hand, if I'm thinking about selling a property, I'm not going to rely upon what I think is apparent. If I think something's apparent, I'm still going to write it down, because I don't want the buyer to say, well, it may have been apparent to you, but it wasn't apparent to me, right? So for my purposes, I'm going to disclose everything, because Kansas law says as a seller, I need to disclose things. Now, what's important to realize is this is true even though we're selling the property in its as-is condition. A lot of people think that, well, if I sell it as is, then I don't have to disclose stuff. And that simply isn't true. As an example, I would suspect most of you have probably been involved in the sale of a foreclosed upon property. And so if you're buying a property from Wells Fargo, Bank of America, Citicorp, or one of those mega banks, you're going to sign that you're buying the property in its as-is condition. In fact, most of those big financial institutions have special as-is provisions that they add, and they want the buyer to sign. And so instead of just saying you're buying it as is, they want to say that about 7 pages over, and over and over and over. So it's pretty intimidating, actually, if you're buying from a financial institution, the number of ways in which they try to qualify the as-is nature of the sale. So most buyers would assume, well, the bank didn't say they knew anything, and the bank, in fact, said they knew nothing. And the bank told me if I bought it, I'm stuck with it. And I bought it as is, so I bought it, I'm now stuck with it. That's actually not true. If you can establish that the bank knew about the condition, whatever it was, then you still have a claim against the bank, just like you would against any other any other seller who lied on their seller disclosure form. So, like I said, the language seems intimidating, but in reality, buyers have more remedies against banks in that situation than you might imagine. And oftentimes banks do know stuff. Banks like to say, well, I've never lived there, therefore I don't know anything. And the problem with that is, you're right, they never lived there, but as a bank, they still have lots of information about the property because, for example, they have the transaction file back at the time the previous owner bought the house and the bank made the loan. They have that transaction file. Well, in that transaction file, there's a contract. Probably is a seller disclosure form. There may be inspections of various kinds. So in effect, the bank is aware of all of those things that their previous borrower was aware of. And when the bank goes to sell, then they should be disclosing all of that stuff. Now, I'm not going to pretend to try to convince you that you can go to Bank of America and say, well, you're lying in this as is clause, so I want you to tell me all the stuff you know, including everything that was in the file back when you made the loan. You could try that, but I don't think it'll work. Bank of America kind of makes their own rules. And so you're going to do what they want or you're not going to do business with them. And that's just a choice you make. On the other hand, it would be my position that even if you bought the place from Bank of America, and even if Bank of America made you sign as is language on 7 different pages, I don't think you're stuck. If you can prove they knew about it, then you still may have a remedy. Now, some of you might think, well, how in the world would you ever prove that they knew about it? And I guess my response would be, you'd be surprised because you usually can. I had a case some years ago down, like Burlington, someplace south of Topeka, a couple counties, and a bank had sold the property. The bank that had sold it, the name of the bank was First State Bank of Louisiana. Well, they had sold this property to a local businessman, and he was going to remodel it to turn it into his home. He was over there working one evening when a friend of his saw the lights and stopped in, and they have a conversation. The guy says, well, how's it going? He says, well, it's terrible. You remember the Money Pit movie? Well, this house is the Money Pit movie. Every time I go to do something, I have something else to do unless it's 3 something else's. And he said, I've got wood rot and termite damage everywhere. And the friend said, well, at least you knew about that when you bought it. And the new owner looks at him and says, well, how would I have known it? No, I didn't know that. And the friend says, well, they didn't tell you? No, they didn't tell me. Well, the friend was a real estate broker and had been asked to do a broker price opinion on the property during the time the bank owned it and had declined. He told the bank, he said, this house has so much wood rot and termite damage, I'm not going to put a value on it because frankly, it ought to be torn down. That's his letter. That's what his letter said. So he sent it to the bank. Obviously, he was not hired to list the property and he was not consulted by the friend in buying it. But that letter was in the bank's file. And so when we found out about it, we were then able to get the bank's file and prove that in fact the bank knew. I suppose you put air quotes around the "knew," but they had information in their own file that would have told them about the very problems that the buyer was experiencing. And the case settled once we got to that point. And I don't know exactly why it settled, but my personal view was that if I were the bank's lawyer and I saw that information, I would have been telling the bank, you are going to get beat up so bad in front of a jury in Kansas. First of all, the name of your bank is First State Bank of Louisiana. Kansans don't like people from Louisiana, so that's strike 1. Strike 2, we've got this information in the file that you clearly knew about. And strike 3, this guy is a local businessman who's well respected in the community. And so while that doesn't technically prove anything, from a jury perspective, it doesn't help. I would have encouraged my client to settle based upon that. Okay.
Vern, I have a question. What happens when a seller lies on a disclosure, the buyer finds out from a repairman saying they have been to the house to repair a defect when the seller lived there? It did not show up in the whole house inspection.
Well, I'm going to assume a lot to answer the question, but based on the idea that this, and to give you a real life example for those of you that, the questioner probably has something specific in mind, but I'm going to give you something specific so you can relate to it. A very common problem is tree roots in the sewer line. You know, here in most parts of Topeka, where older service lines from homes to the main sewer was built of clay tile or worse, Orangeburg, the trees have just infiltrated that line. Now you could go out and dig it up and replace it with a nice solid plastic line that would keep the tree roots out. But as long as you can go in with a Roto-Rooter every year and a half and clean it out, it may not be a big deal. It may be cheaper to spend $100 every year on Roto-Rooter than it is to replace the line. Probably is. You can do a lot of Roto-Rootering at $100 for the $5,000 it might cost you to replace the line. A common problem then is the new owner has the house for a couple of months, and sure enough, sewer line backs up. They have a plumber come out who scopes it and says, "Yep, you got tree roots. Let me clear them for you." And he says, "Well, you know, actually, I've been to this house about every 18 months for the last 15 years because, you know, this is just normal maintenance and you should be aware of it being normal maintenance." Well, the previous owner did not tell the buyer, "Oh, by the way, you're going to have your line Roto-Rooter periodically." And so they didn't know that, and B, that caused them to experience a sewer backup that may have caused some other kinds of damage. And then 3, of course, we now know that we need to have a Roto-Rooter company out every 18 months. So obviously at that point, the buyer is unhappy. They're unhappy with the seller because the seller didn't disclose it. And my judgment is that in that case, the buyer probably has the better argument, because certainly the fact that you need to have Roto-Rooter out every 18 months, while that's not unusual, it's also not normal. So it would be reasonable, I think, that a previous owner disclosed that. And we're assuming for purposes of this comment that the previous owner did not disclose it. Therefore, it would be a form of misrepresentation by the previous owner, likely lead to a valid claim by the buyer. Now, is it a perfect claim? Is it free from all argument? Is it something a lawyer would automatically take? Well, probably not would be the answer to all of those. The number one problem in cases of that size and that magnitude, I always tell people, when you come in with the case, you may have a case, but it may be a case that doesn't have enough zeros. And what I'm thinking about are the zeros in the claim. So a $100 claim, obviously you'd be better off just paying to fix it than hiring a lawyer. A $1,000 claim, you're better off fixing it than you are calling a lawyer. A $10,000 claim, okay, we're starting to get interesting. But still, if you've got a case that's going to have a jury trial for 3 days, then a $10,000 claim isn't big enough. Tell me you got a $100,000 claim, okay, that's big enough. All right, it's got enough zeros. That's what I mean by that. Okay, did you have anything else at this time, Linda?
Not
Okay, all right. So I'm going to leave paragraph 11A and go to the next page then, where we get into, now the 11B disclosures, those are required by Kansas law. Those paragraphs have to be in the contract. So if you get somebody trying to take those out, you just need to know you can't do that. Those 2 paragraphs are required by Kansas law. Paragraph 12 deals with the inspections. Now, this is one where under the license law, it's important to realize that you have a duty to suggest to buyers and sellers, for that matter, that they get qualified third-party inspections. And that's, the license law uses the phrase qualified third party. But we really, to translate that into English, when we say qualified third party, we're talking about experts. And as we go through paragraph 12, talking about inspections, 12B is wood destroying insects, so that's your termite inspection. 12C is the wastewater disposal inspection, where if you have a septic system, you might want to have the septic checked out. Now, I will tell you that there's kind of a rule, which is that septic systems only fail after there's been a closing. Lots of people have septic systems in Kansas, and most of the time they're working. But a septic inspection is not as detailed as you might expect. The county health inspector here in Shawnee County, basically they will look in the septic tank to see if it needs to be pumped. And they will walk around where they think the lateral field likely is to see if the lateral field is leaking. But if they don't see a leaking lateral field and the tank looks structurally sound, then they're going to say it's okay and it's a working system. Now, the reality is county inspections of that variety really don't tell you the system is working. What it tells you is we don't see anything that tells us it isn't working. A failed system will be leaking sewage out onto the ground. Now, for example, right now where we've had all this rain and highly saturated soils, I would judge there are more failed septic systems in Shawnee County today than there will be in August. Because in August, the septic system works pretty well. The grass sucks up the sewage and it doesn't run out on the ground. But when you get the ground highly saturated, then oftentimes the septic system may be failing during a wet season when it does not fail during, a dry season like August. That's just kind of the nature of Kansas. If you want to scroll down to paragraph 12D, and about 2 paragraphs from where we were, okay. The boundary location is a form of a survey. Now, it's not technically a survey, so you have some check boxes here. So we have a mortgage title inspection, which is very basic, and most of the engineers who do those, all they do is they find one corner pin, and then they judge where the house is and where the lot lines are from that one corner pin. And basically all they're trying to do is establish that the house is actually on the lot. So measuring from that one corner pin is all they're going to do. A boundary improvement location certificate, it actually locates the boundaries, but it's not significantly better than a mortgagee title inspection survey. An ALTA survey is on the other end of the spectrum, and that's an absolutely complete survey. And so what happens in those is you actually get your title insurance commitment and you look at all the easements that are listed on the title insurance commitment, and the ALTA surveyor will actually draw each easement on the lot drawing to show you where not only the house is, but also where all of the easements are. Now that's a pretty good survey because it tells you, for example, if the sewer line's easement is underneath your garage, that exposes you to a problem that's a little different than you would have if it isn't. So that's why an ALTA survey is used, and it's used a lot in the commercial business. The reason it's not used on residential transactions is that, relatively speaking, it's expensive. An ALTA survey will likely cost thousands of dollars. Now, I'm not a surveyor. If you want to find out what it costs, call a surveyor, but I'm just telling you the ones I've seen are usually thousands of dollars. 12E is worth just reading to remind yourself of the things that inspections do not cover. And basically it's telling you, well, look at the highlighted sentence. For purposes of this contract, an unacceptable condition or deficiency is any functional defect or any condition detrimental to the health and safety of the occupants. And in the text above, it tells you, well, it's not about cosmetic stuff. It's not stuff that isn't pretty. It's stuff that ain't working, okay? That's a different animal. And then in paragraph 12F, of course, we have the list of inspections that we might acquire. And a buyer can elect which inspections they want. Now, the thing that I hear about periodically in 12F is that a buyer will ask for inspections after the contract has been entered into and as they're working their way toward closing that weren't listed here. So, let's see, let me look at the list real quick to give you an example of one. Okay, so for example, one of them that's listed is private drinking water supply. So that's an inspection we can get. Well, what about a private irrigation supply well? It's not listed, is it? Well, a irrigation well, for that matter, a private drinking water supply, a well really has two elements. One is their water. Well, I'm going to come up with more than two. Is there water? Two, is the water usable for its purpose? And I know, like down in Hutchinson, for example, a lot of homes actually have an irrigation well in the basement, and the water table down there is so close to the surface, you can have a 20 or 30-foot well and water your yard out of it. But the water is not suitable for drinking. So there's a quality of water question, okay? The other question is quantity of water. So when there's a well, does the supply meet the need, whatever it is? If we're talking about a house, then does it provide enough water to operate the home? If you're talking about an irrigation well, does it provide enough water to irrigate whatever it is that we're irrigating? So when we talk about a private drinking water supply question, that's a little bit short of the full question. And you need to think about, okay, what is it that we're worried about? Are we, asking for the right inspection? From a license law perspective, it tells us that we are to inform buyers and sellers that we are not experts at all of these things and recommend to them that they get inspections which are necessary. So that's important to realize where the boundary line is between being a realtor and being an inspector. Another question I'm sometimes asked is, okay, if the buyer has ordered, say, a structural inspection, should the realtor be present for the inspection? Well, there's a couple of different pieces to this answer. The first one is, do you just give your passcode? Used to be, do we give the combination to the lock to the inspector? For my purposes, generally the answer to that should be no. You would not want to give access to property to someone who is not a licensed real estate agent or broker. And the reason is from a liability perspective and from a contract perspective, because contractually, when we take a listing, we get the seller to give us a key, and we're supposed to be using that key for our purposes and not for other purposes. So I would want to look at the listing agreement to see what was the purpose of us having a key. What did it say we were going to use it for? The second piece of the answer here is whether or not you should be present. From my purposes, if I were your broker, I would say yes. Now, I'm not your broker. At the end of the day, you should do it the way your broker wants you to do it, not the way you think Vern tells you, because I'm not worried about the liability that you create, because you don't create any liability for me by doing an inspection. So for me, I would want you there from the standpoint that you would see and hear what the inspector looks at and has to say. That can be important for a couple of reasons. One is obviously it helps you should renegotiations be required. Two, there may be things that the inspector misses. Now, if you think the inspector missed something, you don't say, hey, inspector, you missed X. Instead, you say, I was looking at X, and I'm not sure if that looks right or not. What do you think, Mr. Inspector? The point is, you're not the inspector, and you don't want to take the place of the inspector. You don't want to do the inspector's job because you don't want the liability for doing the inspection well or not. It really should be up to the inspector to answer those questions. It is appropriate for you to point out things you think the inspector may have missed. Now, you don't have to say, you missed something. Instead, it should be an inquiry. I see X. What does that mean, if anything? Okay. Okay, Linda, let's scroll down to paragraph 14, unless you have some questions. Another half a page.
Just checking my phone.
Okay.
There's a question. Oh, there is. We give inspectors codes through showing time all the time. Should we reconsider that?
I didn't hear the first part. I didn't understand it.
Realtors give inspectors codes through showing time all
Okay.
the time. Should that be reconsidered?
Well, from my perspective, it does create an area of liability, especially if, depending on what your listing agreement says about that. So the answer would be read your listing agreement and see whether or not the permissions that you have for the use of the key include providing them to inspectors. If they do, then fine. I think the seller has agreed to that, and so the seller has authorized you to do that. And I understand why you would want to do that, because it's easier for you and one less trip to the property. But if you don't have the seller's permission to do that, then that could be a point of liability and risk. So if you have it in your listing agreement that says you're going to use it that way, that's fine. If not, then I suppose you could get there by sending an email to the seller. By the way, the buyer's appraiser is going to come out Thursday afternoon. I know you guys are going to be both at work. Is it okay if I give them the code to get in, or do you want me to be there? You could ask the seller that, and then that would make it very clear. Okay.
Can I ask a question just for myself?
Sure.
There's been a lot with this crazy market. Heard a lot of times where buyers are absolutely foregoing any sort of inspection, and then possibly coming back on the seller saying there were issues when actually they did say, I don't want an inspection. Is there really a liability down the road for anything like that?
You know, that's one of the many questions in the quote current market. You know, I've seen cash offers written where there's no appraisal contingency. I don't know that I would do that. I think if I were going to make a cash offer, I would want an appraisal contingency. If I'm going to buy a house, I would want to have the sewer line camped. But I understand that buyers are so anxious to make their offer the best offer that they are foregoing those things in order to do that, just to make their offer look better than other offers. Now, I think if you do that, if you forego an inspection or an appraisal, then as a buyer, you're taking that risk. So does that mean the seller can avoid disclosure? No, I don't think the seller can avoid disclosure. There's a difference between a buyer foregoing inspections and a seller foregoing disclosures. But it does make the seller disclosure form even more important if the buyer is not going to have inspections. So from a practical standpoint, the buyer should not have a claim if the buyer didn't get an inspection. If it's something the buyer could have found with an ordinary inspection, then my opinion would be the buyer stuck with the deal they made. On the other hand, does it increase the risk for the seller and perhaps the realtor when buyers forego inspections? Yes, I think it does. There's a reason that the license law says we are to encourage people to get inspections, and that reason is because transactions work better if people get inspections. They just do. So from a legal perspective, we want people to get inspections, and that's the way this contract is written, is to encourage inspection. I do understand in the current market, people are foregoing them. That's a bad idea. It's a bad practice for buyers, and it's bad for our business, for the agent's business. Okay, paragraph 14 is the brokerage relationship paragraph. This is one of the most common violations the Real Estate Commission finds, is that either we have failed to complete this section accurately or at all, or maybe only partly. So the point is, this is a disclosure of the agency relationships that exist with respect to that transaction. So if I'm writing an offer on Linda's listing, okay, I know Linda is the listing licensee, and I should know what kind of agency relationship she has because the MLS will tell me, or if it doesn't, then I should ask her. And then the selling licensee, well, that would be me. And I should know what kind of agency relationship I have because it's me. I should know what documents I have signed. The Real Estate Commission wants to make sure these disclosures have been made to buyers and sellers as they sign a contract. And so you shouldn't be filling these in later. I'm sometimes asked, well, if I'm writing an offer on Linda's listing and I don't know what kind of agent she has, can I just leave that blank? Well, you shouldn't, because it's supposed to be a disclosure to your buyer at the time they sign the offer. Secondly, Linda may miss it. She may forget, or just, ignore the fact that there's a blank here or a checkbox that isn't checked. Now, in reality, the way the audit would work, if Linda gets audited, she's going to get fined for failure to disclose. If I get audited, I'm not going to get fined because I didn't fail to disclose anything. Now, in reality, from my perspective, I probably did fail to disclose something because I should have asked or figured it out before I wrote the offer. Okay. If we scroll down to 15, 15 is talking about the fact that there may be another contract, and certainly in this market where we're dealing with multiple buyers chasing the same property, we may find ourselves where there are, there are other contracts pending. Obviously, the buyer on the second contract needs to know that, and that's the purpose of paragraph 15. So this paragraph would, at least some of the time, be not applicable. Paragraph 16, time is of the essence. This is that paragraph that says if a date is specified, then it's important. And so that goes back to that closing paragraph when I was talking about the closing day. And 17 is saying, basically just repeating what Kansas law is, which tells us that we have the ability to do things electronically. We don't have to meet face to face. And we have certainly figured out in the last 14 months that we can do a lot of stuff electronically and we don't need to meet face to face. I am somewhat concerned about one of the trends that developed in the COVID year, which was people buying houses without seeing them. Is it legal to do that? Sure, but it's obviously increases the risk, and that risk is not good for our business. It's not good for buyers and sellers. Okay, well, let's go to paragraph 18. We're down to the last page of the contract, and we're ready to talk about the mediation paragraph. I think this is a very good clause. Now there are different varieties of these clauses around the state. So if you're dealing with a contract out of Manhattan or Wichita, you will find slightly different language, or Kansas City, you'll find slightly different language than you might find in this one, okay? So for example, right now, I don't believe the Manhattan contract has mediation at all, but the Manhattan contract says if you have to sue somebody, you get your attorney's fees. So this contract does not say that. Under the terms of this mediation clause, if a buyer and seller want to fuss with one another or want to fuss with you after a closing, and usually, of course, that's a buyer upset about non-disclosure. That's the most common. Then before you go to the courthouse and file a lawsuit, you have to engage in mediation. So what is mediation? Well, it's a process where a third party tries to help you find a solution to a problem that you're having, okay? So for example, let's say there's a boundary line dispute between a neighbor and an owner. A mediator would perhaps look at the boundary line, look at the surveys, and try to help them find peace where maybe the surveyed line isn't exactly where the line would be if you respected usage over many years. Could that be resolved with a trial? Sure. You could have a trial, bring the surveyors in to testify about where the line is as a matter of mathematics. And then you could have other experts and witnesses come in and say, but here's how it's been used, and that's different than the mathematics. And you could get to an answer by way of trial. At the end of the day, the judge has to decide which surveyor to believe, I guess. And you spend thousands and thousands of dollars getting to that answer. Mediation is a process where a third party actually meets with both sides and tries to see if we can find some middle ground. And so it's a tool of dispute resolution. It's called alternative dispute resolution. And it's way cheaper than hiring lawyers to fight things out. Boundary line dispute. Well, I had one here, oh gosh, probably 15 years ago, went all the way to the Kansas Supreme Court over a boundary. And honestly, the boundary did not matter. And, if you stood at the street and looked at it, there was a fence there today, but back at the time of the dispute, there was no fence. A single property, I'm going to say 40 acres, had been carved into two 20-acre tracts, and it was really just a piece of pasture. It wasn't even in the city. And if you stood and looked at it before the fence was built, and you said, is the value of either tract different if you put the pen here or you move it over and you put it over there? And you would have said, no, the value is the same. It doesn't change just because you've moved the pen. In this case, it was 17 feet at the street. A quarter mile away at the back of the property, the two surveyors agreed, but there was a disagreement out at the street. And so the whole fight was over this triangle that was created by the two differences between the appraisers. We spent $50,000 in legal fees fighting over 17-foot discrepancy in a pasture. That makes no darn sense from a practical standpoint. It was a situation where two very opinionated people met, didn't agree, and they wanted to go to the mat and find out. And mediation would not have worked because they both would have ignored the mediator. But for most disputes involving unhappy buyers, mediation does work. And I don't know, Larry Root does the mediations under this contract clause for us here in Sunflower. And I'll try to remember to ask Larry, just because I do get asked by people sometimes how often it works, see what he tells me. I would say in my personal experience, 80% of all mediations result in success, meaning the parties don't go to litigation, but rather accept some resolution through the mediation process. Now, sometimes that resolution is they just say, life's too short, it's not worth going to the courthouse, so I will give up my quest. It doesn't always mean money is paid or other adjustments made. It can just mean everybody stands down to where they were before they started. Notice the second paragraph talks about things that are excluded from mediation, and most recently we added, let's see,
you entered the small claims court limit.
yeah, where is it? Which subparagraph is it in? I'm trying to find it.
G, it's the last paragraph under G.
Yeah, it's G. Yeah, H is last, which is license law, but G says anything that could be solved in small claims court. So the idea is, if you can spend $40 and go to small claims court, you should do that rather than go to mediation, because mediation will cost more. And so we added that the last time we were making changes to this section. Okay. Additional provisions is a little bit scary to me as a lawyer because basically it lets you write your own contract language. And the only thing you have to remember is when you start writing additional stuff, try to make sure it's clear and understandable. And you haven't left anybody with, I wonder what that means. Now that's easy to say in the abstract and hard to do in practice, because a lot of times you write stuff in paragraph 19, and when you write it, you understand it, and I send it over to Linda as the listing agent, and she reads it, and she thinks she understands it, and she meets with the seller who says they understand it, but the buyer and the seller actually don't mean the same thing with the language. So you may have trouble with additional provisions because you're using language that hasn't been tested by time. That's one thing that if you're not on the committee that writes this form, you wouldn't realize how much time is spent. But just for example, that last change we were talking about, the decision to add small claims court, that was probably, even as easy as that one seems, that was probably a 20-minute conversation, if not longer. So a group of about a dozen of us sat around, experienced real estate people and me and Linda for the association, and we sat around and talked about how that language should be. You know, first of all, was it a good idea? And then secondly, what should it say? So it's pretty hard fought. And when you start messing with things in paragraph 19, you may be unwinding those hard fought, closely considered elements that the committee thought about. All right, well, we're just about out of time. So let me see if there are questions.
I don't have any questions yet.
Okay. Well, we'll wait a minute or two here, see if anybody gins anything up. You want to do your admin stuff, and then we'll check on see what we have for questions.
Yeah, thank you for reminding me. I know that there were some issues with people being able to get onto this presentation. Of course, they're not on, so I can't apologize directly to them, but I will. But I would like those that are with us to remember we have 2 live events coming up next month. YPN is presenting another appraisal panel that will be at 11 a.m. at the Rosewood Event Center, and you can register for that online. And then we have our membership meeting June 11th, which will be again at the Foundry, and our sponsor is Community Bank. So please sign up for those if you intend to. If you haven't, please consider it. And thank you all for joining us today. And I still don't have any questions, so.
Okay, well, we're going to